press continue in hot water.
Play on Friday?
You can call that play, yeah.
So I guess we didn't play.
Well, no, we faced a very tough team. We can't be competitive unless all our players are around. They're really good. They have some plays.
Oh, really?
Yeah.
Where's your sport?
Basketball. There's a pinball here.
Jason's on
Yeah,
it.
Jason can explain to you
No.
what happened. Maybe better than me. He's asking about the game on Friday, Jason. I didn't recognize you there. Where were you really just hiding there in the shadow?
Came out really cold in the first and second half.
Okay.
We played decent defense in the first, and then it just fell apart in the second.
This is a blowout?
Yeah,
Okay.
big blowout.
So as a Penn Law, I am the intramural league, and we have a faculty and staff team that plays in this league. So number one, right? So we have a little bit of an age gap, but yeah. So it's getting to yeah to be competitive. That's fun. It's definitely fun. I put water down there for you. Well, let's get you
I played softball.
Yeah. We did a faculty student softball game last spring. That was also sort of a thing. So it's all on the line. Stick that in your gosh, got it. And then flip the mic part to your and probably better to put it on that side because you'll be turning into your slides and then you turn away from that mic.
I see.
Hey. Okay. Very good. How are you? Yeah. Good. I think that's it. And then this is your remote.
Oh, yeah. This is after you went into. I was here to hear.
Okay.
And then gray out.
Yeah.
Fabulous. I was and so basically the way the format is
But no, we figured out that we can have them on.
have them on.
Yeah, because otherwise it's just like
Dark. Yeah.
too dark.
But you'll give your presentation for
Yeah, better. That's much better. And we don't need them to see the
I'll sort of
screen.
you so people will sort of just get their question. I'll write it down. And then so you don't have to worry about knowing anybody's name. Like I'll just call it. Now if it's students wants the entire lesson, it's fewer people than we expect, then I might deviate from that. And especially if it's all deviate from that, then we can also call on them, but we can maybe have them.
Good.
the game on Friday.
It's not something.
Kid-
Man, you picked one to, that was not,
Not
not
great.
good. No.
Well,
They were really, really good.
yeah, Gibson had plays.
They had plays, they passed the ball in a way no other teams passed the ball.
Really?
Yeah.
Who's this?
Yeah, they,
Wow.
they like figured out right away where it was on, and they did that thing where they throw it to the guy in the middle, and then he like shoots it back to a guy cutting the
wow.
basket. I mean, it was just like,
This is-
all right, this isn't gonna
So
go
may
well.
have scouted us. They may have scouted us.
No, I mean, we switched it a couple of times too.
There's not a lot speaking like that.
So how's it going?
So who did you lost my kids? Yeah, I think it was 28. Seven.
Time to do this point, but it wasn't work like time. Yes.
And then
And CTE. Haven't met yet, it's just fall.
Okay.
Looking forward to that. Been very good conversations.
Good.
Thank you.
So, you know, you're gonna keep the cube?
Yeah, what I said to Stephen was if it's a more intimate thing, then we don't have to do it that way. And he left it to him, he wants to,
Yeah, a bunch of people who want to participate.
okay.
Yeah, all of them.
I get all the glory, and Tom does all the work, which is like the way I like these things. Yeah, you do.
We can still tell them.
So were you coming anyway?
Yeah, I was, what they were thinking, letting the delicious lunch there was not persuasive.
Doesn't work on
It's
At 11:10. These guys were Arlene. Remind me, me and I had several other people that the public interest committee was meeting. We were waiting for us tonight. Today I voted. Didn't know I was on the public.
That's a good one.
Aren't you on the audience?
That's what we want to know. Yeah, but you know, I got an earlier email, I think it was a mistake.
The scheduling emails must have been some sort of.
Right.
All right, we're gonna go ahead and get started. So obviously today we have Stephen Meter, who came all the way from Palo Alto, graduate of University of Pennsylvania undergrad, graduate of MIT, graduate of Harvard Law School, and here today to present about the DEC and IP clinic. Since we have a more intimate group, so Stephen has said he would entertain questions during his presentation, but there will be obviously our 20-minute presentation followed by time for questions, but rather than keeping it queued because it's a smaller group, just raise your hands at the end, and I'll still call on folks so he doesn't have to do that, but turn it over to Stephen.
Thank you very much, Praveen, and thanks to all of you for coming. It's really a great honor and pleasure and privilege to be back at Penn and to have an opportunity to speak with you about a very exciting prospect, which is the development, the creation, and launch of a new intellectual property clinic. In fact, I think a new kind of intellectual property clinic. Relatively little precedent for this, which I genuinely believe can be part of the answer to one of the world's great needs, which is cultivating a generation of leaders in innovation. God knows the world has many problems, some of which have been and will continue to be solved through innovative technologies. And our graduating law students can, in my experience, be a very important part, play an important role as trusted advisors and indeed even as leaders of the enterprises working on those kinds of problems. There is a real market need that I would identify, and this is based largely on my own experience. I've worked as a practitioner for something over 20 years now in a variety of roles. And some of the most challenging and really value-adding intellectual property assignments that attorneys get. I've listed some typical questions. They are really all questions that blend in a very intimate way, in a very integrated way, legal expertise along with some measure of business and technology or product insight. When, for example, top of the list, which a company or a university researcher might ask, which of our new inventions does it make sense to patent? Which aspects are most worthwhile to protect, and how will that help me? Why should I do it? You know, there's a certain amount of legal foundation that underpins how to answer that question, but that doesn't get you all the way there. What you really need, as I will explain, is something of a dialogue, a very interactive and substantive dialogue in which legal advice is being provided, but concepts of business and technology are flowing back and forth. Many of the questions that I answered, for example, as outside counsel in a major corporate law firm, even though we weren't dealing as often with professors inventing new inventions, but it was the same kind of situation. If I was advising a company looking at a major M&A transaction, acquisition of an innovative product line or innovative company, they wanted to understand how good the patent portfolio was. They wanted to understand and appreciate how material and how significant the IP risks that were known were in terms of how they would affect the business plan and the business strategy going forward. Legal answers got me so far, but really what I saw again and again was the opportunity to add maximum value came for being able to integrate law with business and technology. How do we prepare, should we, and how do we prepare law students to best step into that role and take advantage? Certainly I'm not advocating that on day one Graduating law students will answer these questions, these type of questions unilaterally, but as I've said, it's really about helping students develop a framework, an analytical framework, and an experience base where they know the questions to ask, and they can be a value-adding part of conversations that get to the answers of these questions. And I'll give you some examples today. One way of thinking about this in shorthand is as a certain type of mindset for attorneys. And many of my good colleagues throughout my career would take a very conservative mindset, and I think it's defensible, where when you get one of these sort of mixed questions, you issue spot, you identify the legal aspects that can be answered, and essentially as a conservative attorney, you give some guidance to the client and say, look, here's the part I can tell you, here's the law you need to know, now you go off and figure out the rest. You figure out how it affects your strategy, or what aspects are most valuable or important. And what I'm really looking for is how we can help students ascend to what I think will give them an unfair competitive advantage in the market. Lawyers who can say, well, let me help you think this through. Let's think this through together. Even though I don't know as much science or business as you do, I can help you think this through. That's a noble and very value-adding goal. And I think we can equip students with such tools, in part through a clinical experience. It's actually very straightforward how to make these decisions. I think if Chris Yu were here, he could explain it to you. Oh, there we go. It's very straightforward. You just plug in. So I think we can cover this with students in more or less one semester, and then they know the answers. What we actually find to be more effective, and more work that I've done in practice with associates, including many summer associates who were law students at the time, is to engage in as I say, a conversation with innovators and inventors and company leadership. For example, if you want to provide advice on patent strategy, which inventions are the most important ones to protect. I'm giving that example, by the way, because that's one of the, as we'll discuss, that's one of the, I think, common core sort of bread and butter opportunities that could come up for this clinic. Penn itself generates a lot of inventions, and one thing we can do is have students help Penn make decisions about patent strategy. So really a lot of the exercise is what I would call critique and refinement of value propositions. This is an exercise that in part is really about business strategy and understanding what makes innovation valuable in the marketplace. As a student, you can learn the questions to ask. You can do some competitive research, both before you ask the questions and after. And what you're really doing is engaging in a dialogue with the inventors in which you're asking them questions they ought to be asking themselves. And they're really going to benefit from the process right away. So as the student gets educated by the inventor, researcher, or the entrepreneur explaining their business model to the student or explaining their invention to the student is being trained in this clinic to ask the kinds of questions that are really the right discipline that the inventor should be asking themselves. Probably haven't yet, because most of them don't. They don't always ask themselves the business questions. Going through that process, the student becomes empowered. They get the knowledge they need to come back with, at the end of the day, sophisticated and practical thinking about patent claims. But meanwhile, along the way, the client, their time isn't being wasted while they wait for something good to come. It's actually a useful and valuable conversation for them. They are being essentially guided and prepped along the course they need to walk if they're going to be able to express the value of their invention and their technology to, for example, the venture community or to customers. They need to be able to explain it to a smart law student if they're going to have a hope of being able to explain it to a customer. And I'll show you just to give you a kind of a framed way of doing this. The risk of oversimplifying slightly, the questions that students need to ask if we're looking at this kind of project, new technology, what's valuable about it. I use the acronym NADC. We use this a lot at SRI International, where I work today. There's books published that describe this. It kind of balances talking about the approach, which is, sort of what's the technology here, And I need to know enough about your invention to understand that it's feasible. Help me understand why this will work. But let's not get lost in that. What we really need to start from is the need. What is so important and valuable about this technology? What compelling problem from the standpoint of the world or the market, customers? What compelling problem is being solved? Let's start there. Sometimes just asking that question alone is worth several rounds of dialogue, because a scientist, for example, might their breath has been taken away by the elegance with which they were able to solve a very difficult problem. But that doesn't mean that solving that problem delivers commercial market value. It may or may not. And spending some time with this, I'm not talking about spreadsheets or something deeply quantitative about how many units of something are going to be sold, but more at a qualitative level. Why is this going to make a difference to customers? So you have dialogue about that. You have some dialogue about, okay, can you explain at a high level, convince me that you're going to be able to solve that problem? Because in fact, if it is a valuable problem, then guaranteed many other people are working on it, probably have been working on it. People have been coping somehow up until now. Why? Convince me that your approach is going to be feasible, and then also convince me that you have some understanding of what the baseline today is. What are people able to do today in addressing this problem? And help me understand how yours is better. Why is your solution different and better? Is it really advantageous? That's another area where sometimes entrepreneurs get sloppy. I think academic researchers tend to do a somewhat better job of literature search and taking the prior art seriously, but it varies. So this is a discipline of asking these questions. By asking these proper questions, we help the client articulate and refine their invention better, which they need to do, both expressing it and also refining their own understanding and appreciation for what's most valuable. And that enables the student in turn to produce work product that presents advice that says, well, here are the aspects, based on what you've told me, here are the aspects that are patentable, that would drive a patent strategy, and here are the things I would claim in a patent application. Student is not actually going to write a patent application. Student is going to write what is in essence a strategy document, a very, very concrete set of well-reasoned and specific recommendations based on what we've been told. Here's what we would and wouldn't emphasize in terms of patent protection, and I would guide students towards framing that in a way that looks like patent claims. I'm going to show you one or two projects as examples of this to make it even more concrete, and they generate some questions. These are all drawn from the world of digital media, where I've done a fair amount of work. There's plenty of that, and there's also plenty of other research in medical technology and other areas. I don't mean at all limited to this, but this is illustrative of I think, a rich area that students would enjoy, and that I think Seas and maybe Wharton would be a rich source of opportunity. I'm showing you a picture from, it's an IEEE diagram. It's a very prominent engineering society involved in standard setting, and where engineering meets industry. And what they were able to envision as recently as 1979 was your wired home, the cutting edge, state-of-the-art wired home. So wireless wasn't even part of the equation. Maybe more importantly, architecturally, if you can't read it from where you are, but you can see from the sort of the feel of this figure, it's classic hub and spokes. So there's something very central. And what's at the center here is some command and control, almost military language, and then various things hanging off that are in the home, like a VCR and a fire alarm, and various things talk to this central computer. We have one little outlet to the outside world, which is TV antenna. Even picks up UHF signals. What's happened since, these are my kids, but the actual living room not only is wireless, but has a completely different feel to it in that there is no central computing hub. There are lots of computers, and much of the computer power leaves and goes every time they leave the room, and then it comes and it works together in a very ad hoc way. Everything plugs into everything else or doesn't. What is a TV screen anyway? It's a display. Anything can use it. Multiple things use it. The reason I use this by way of introduction is that many, many interesting innovations are arising out of this revolution, will continue to, and they raise fascinating questions of IP, both on the copyright side and in the patent realm that we've been talking about. And I've been fortunate to have the opportunity actually to give some very interesting copyright advice to some large clients and to some small clients who've been doing subversive things in the area of how we consume media, how we're connected to our music, our television, our information. I have advised companies on questions like, let's say the content is owned by HBO and you're a subscriber, but you don't want to watch it in your home, you want to watch it on your cell phone or your iPad somewhere else. Your subscription agreement through your cable provider doesn't really let you do that. They didn't think about it, they didn't give you that right. So what about the internet company, which actually is called Sling Media? There was a company that does this now. These are questions that I've advised on in the past. These are, I don't know what the questions in the next 2 years are going to be, but just as examples, these form very, very nice blended law and technology and business research assignments where students can help assess the risks associated with various designs in light of copyright law and copyright doctrine, things like fair use doctrine. That's one set of questions. There are also questions, it's a very fertile area for patent protection, which is what we were talking about earlier. And in both the way these kinds of systems are built, the underlying architecture, technology, but also the features that users get to experience. That's a very important area for patents. To show you again an example that came from the domain of search engines. This was a piece of work that was done by a summer associate and a junior associate about 10 years ago when the search engine space was a little more competitive than it is today. It wasn't all about Google. There were some other companies. And I'm not going to walk through this chart, obviously, but the point was to show that somebody at a law student level with the kind of framework that I presented, that NABC framework, was able to have dialogue with business leaders at the search company and with engineers, and really break down, first of all, what the categories were. The kind of the columns of this chart are, what are the high-level areas of innovation that seem to matter in the search engine arena, directions. And some of these were very user-visible, and some of these where there were lots of ultimately crowded work that had already been done, turned out to be things that were very much underneath the hood, like how the search engine crawl, what techniques it uses to crawl various websites. What we found that was interesting, the student did research to see where patents were already being granted and sort of categorized them, and came up with this really amazing insight, which was that the more invisible stuff that was kind of incremental in nature got the most patents, and that very, very highly user-visible features, interesting new directions for search engines, were not so well patented, and came back with very concrete guidance about, based on what that client was already doing, saying, yeah, you ought to really patent the heck out of those areas. You have interesting work going on and relatively open white space over there that seems like it would be very valuable for your business based on what you've told us. And the student didn't need to understand how search engines really work. They didn't need to understand technology. They were obviously familiar with the internet. They used search. They knew what it was. They understood what these categories were from dialogue with the company. And were able to, in a matter of essentially a couple of months, produce a meaningful piece of analysis with some senior supervision. But that's a particularly strong example I was proud of. I think it's illustrative of at least one of the kinds of things students could do. I'll just speak a little bit about briefly how this compares and contrasts with some existing IP clinics. There aren't a lot of them, but it's becoming a popular idea. And there are a few successful IP clinics that are out there. I'd say two of the best known are at Harvard and at UC Berkeley law schools. The Harvard one used to be Stanford. It's basically Lawrence Lessig. Stanford's trying to figure out, I think, what they're going to rebuild it into. They're both very policy and advocacy oriented. That's, I'd say, a little bit more traditional for law schools to do. They're, stock and trade is sort of amicus briefs and position papers advocating certain positions. And that's fine, that's good stuff. And I wouldn't be, opposed to doing some of that. It doesn't hit what for me is very important, which is substantive engagement with innovators and their innovation. Helping a client figure out something they need to do to solve a concrete problem for them. Not, figure out what the right public policy is, but, okay, so how does this company or this inventor figure out the solution to their problem? That's an advantage, and it is, as of right now, I think relatively unique. There's been some amount of work doing, I would say, more purely transactional support that doesn't seem to get as deep into really advising companies about their technology. It's more about the actual agreements. So I think we have opportunity to do something that's relatively unique, but seems to me clearly it's unique but advantageously unique. I believe that would be exciting and fun and equip students with what I call an unfair advantage. I think it really would, in terms of making them especially valuable to businesses and clients, and it would certainly be beneficial for the law school and also for Penn more broadly in various ways, including by helping, to some extent, better commercialize Penn's technology, but also really in providing with a more fundamental mission of demonstrating and establishing the best ways to educate a new generation of top students. This can be a model for a new way to do it that adds a piece that I think isn't there today, but that's quite valuable. And ultimately, I think the employers who are fortunate enough to work with students with this kind of training and who come from a place like Penn will be well served and will be better able to solve the real problems that society needs solved. I think students can be real, as I've said, partners in the innovation process with the benefit, in part with the benefit of this kind of experience. I have appended just a couple of points about research interests that I have. It was suggested some folks might be interested in that. If you have questions, I'd love to discuss it more now or later. Some of the things that I have looked at and spoken about, or generally written, not law review type articles, but more industry type pieces, have been along the theme of what actually happens in the business world when IP assets are created and enforced in various ways. So this is, in a sense, an empirical or just an effect, a consequences-oriented way of looking at the policy decisions. So there are a lot of, for example, take what kind of technology should be patentable. Should software be patentable or business methods be patentable? Well, what happens when it is? We have 20 years of experience with aggressive patents in the United States being granted in that area. What happens to our innovation? Is it chilled by these patents? Is it not? What can we tell and infer from that? And there are other areas where sort of IP meets business, and issues of either competition or effect on markets come up that are very interesting to me. As well, I have a pretty serious interest in Talmud, and I've done some comparative law work. That's not so relevant to the clinic, but it is relevant to me, so I thought I would share that. Appreciate the opportunity to speak with you. I don't know if I'm on more or less on time, but happy to take questions if you have any.
Great. And so again, we're going to not keep a queue, so feel free to just raise your hand. I'll call on folks and go ahead, folks.
So, as you noted in sort of your review of what other clinics are doing, nobody's really done this before. Why is that, do you think? What is it? I mean, what is it that's different and unique about this that you think? I mean, it seems the way you present it seems so obvious that this is a good thing for students and a good thing for the university. Why has this not happened before?
So you would be very good at this process.
Right, exactly. Use your process.
That's exactly. You must be very skeptical. If the need is that compelling, it's like, okay, well, am I the only genius who thought of that? You're absolutely right. You're absolutely right. I know a little bit about the limited experience so far of some places that have tried it, but it's mostly hearsay. So I know that I've been told that there were experiments with this at Arizona State where I don't think they had enough of a flow of high-quality problems to come in to feed the clinic. There wasn't enough of a vigorous research environment there to feed it with the right problems. There is a pilot program along these lines, narrower, but along these lines, and it's small, that is started this year at UC Hastings. I know the faculty member who's doing that, and I wish them well, but they're kind of starting small and branding it very experimentally. It seems to me the reason that this is not, part of the reason this is not trivial to do or hasn't been done a lot is a little bit, I mean, this is my own speculation, there's something of a generational aspect of how many peers we have who were really that genuinely interested in the blend of law and technology and business. In my peer group, this was a very powerful differentiator for me professionally. But I see, I think the time is right now. There's demand and there's interest. I'm told that something like a quarter of your students take the IP intro class now, and perhaps more would if there was room. You have a lot of people not necessarily going to specialize in IP who want to understand these issues. So, and who would be interested in, this kind of stuff. And I don't think that was true. My guess is that wasn't true for faculty or for as many of the students 15 years ago, so it's taken a while to build. That's my guess.
So to follow up on that, how do you handle the flow problem? That is, how do you generate engagements that provide these opportunities for students?
How do we generate enough?
Yeah.
We have a twofold strategy, Penn and external to Penn. So how much of the right quality flow and the right type of projects will come from Penn, I need to investigate. I'm told there's a lot of demand. I'm meeting this afternoon with your Center for Technology Transfer. I've been given some numbers that suggest, there's an awful lot of work there. I have to kind of drill into that and see if it covers everything. I think either way, it would be useful to maintain relationships as long as they're consistent with what the university can legitimately do as a student clinic with particularly startup companies outside, perhaps other nonprofits. And I certainly have, I can offer to help with that. I mean, I think a part of what the director would do is to do some business development along those lines. And I believe the demand there's screaming demand for this kind of analysis in innovative startups because they don't have the deep in-house departments to do it for them.
Gideon.
Yeah, so thank you first of all. Naturally, this is an IP-oriented clinic, so IP should be the focus, but there are some studies, at the same time you're focusing on creating value for the client, and there are some studies showing that perhaps patents are not the best way to secure value for the client. Have you any thoughts about that? How do you make the first cut decision whether patents is the way to go or not the way to go with respect to a certain company?
I'm actually intrigued to know what, like, are there specific, perhaps this study itself, is identifying by area, this area, yes, this area, I can tell you the wisdom I have on it, but you may know more.
Right, so generally, don't want to overstate the literature, but I think there are colleagues here that can correct me. For pharmaceutical companies, patents are very valuable, but then for many other sectors, companies operating in other sectors, let's say that the evidence is inconclusive.
Okay, so there's I think a well understood model for how patents add value to companies in pharmaceutical companies that hasn't changed. It's well understood, it was true 40 years ago and it's true today. In fact, I have a presentation on this, looking at stock market movement as a result of so what's interesting is you can take a look at a product that's big and it's in the market and there's a patent ruling about it, and you look at what happens to Microsoft or Intel, and then you can look at what happens to Johnson & Johnson or Eli Lilly. You have, I'm trying to remember which drug it was. It was a popular drug that went off patent surprisingly early. It was only a couple of years early that it got invalidated, or its expiration date. It surprised the market, and this major pharma company lost multiple $1 billion in market cap overnight. That generally doesn't happen with large, mature software companies. What I have noticed, however, what's screamingly clear the last decade, the last 5 years, is that in software and in internet businesses, investors care more and more and more and more about this because there is a food chain. So the patents for it's not that the business, the new startup business that patents these things is going to go sue their competitor startup business. That's usually not what happens with the patent. It's not like in pharma where there are generic companies that they have to get rid of. What does happen is that it makes them a much, much more attractive acquisition vehicle acquisition target to, let's say, Google or somebody like that, and therefore it makes them a more attractive venture capital target. So I know it used to be that I had to, argue with or persuade to some extent VCs to be interested in this stuff. Now that's not true at all in software and internet. They're demanding, they challenge me with lots of questions about what is the patent position of this, this client of yours. They want to know because they see what happens in the smartphone space, for example. So I believe that has changed.
So one question is, how do you translate all of this into a student experience? So you might have students that have taken the Intro IP course, right, which may or may not be a broad survey-based course. It might focus in on a particular area or another, but some may not have even taken that, right? And they want a clinical experience. They enroll in this clinic. How does a student without a science background, technical background, much knowledge of IP, granted you could have prerequisites, but how would they sort of come in and interact with this clinic in order to do work like this?
Okay, well, I'm going to go back for a moment here. One of the things about this, I call the NABC framework, is that it also maps to those who know the patent statutes. These are sort of keywords in some of the patent statutes too. An invention to be patentable has to be useful, has to be enabled. You have to describe how your thing works in sufficient detail, and a lot of the issues tend to be about what's called prior art, and are you really differentiated? This is probably, though, a sufficient level, honestly, to understand in order to do the work effectively. You don't need to know that much more about those statutes. I think students who have, and who have looked at some cases involving them, will have a greater appreciation for what prior art is and some of the nuances. But you don't necessarily need to know those nuances in order to do effective work. You can certainly be prepared quickly with what you need to know as a practical matter. What's probably not dealt with a lot I wouldn't either if I were teaching basic patent doctrine, would be things like need. That court doesn't really care whether it solves a compelling need or not, other than, I guess, at the damages stage. So, but these are very high-level concepts. So this is what, to me, a student needs things like they need to have a high-level framework. They need to have resources that they can turn to where they need to drill down and get more detail. So they need to have a set of backup materials that they can look at that will, they can consult and find out more. And they need to engage with the client. I certainly found, I'm speaking from personal experience in terms of working with summer associates and junior associates who they weren't particularly well trained in IP when they arrived, and some of them were, most of them weren't. And we're able to do this kind of work. In terms of being having an engineering background or not, that really depends what kind of, I have to survey students who want to come and make sure we have a range of work. My target is to have work that will, as I say, appeal to people who are interested in use of technology. I think we should have a lot of projects like that, not necessarily ones who are interested in understanding how technology works or how to design it. That would be kind of a subset. And for those students, I tend to match them with assignments that really, where that would benefit, where the analysis would benefit from a deeper technical knowledge. But I think hopefully a lot of the assignments can be handled at a higher level.
So in your experience, what are the qualities that make a lawyer successful in this arena? What are the kinds of things that you'd want to nurture in your students? What do you look for, maybe even in associates that you hire? And how do you translate that to the clinic?
I had an opportunity to discuss that briefly this morning with some of the folks in the room, but I was sort of trying to paint a picture of a layer cake. You know, there's a danger here in focusing a lot on clinical experience, which is obviously just one piece of a long curriculum, as if, you know, this is not the tail that wags the dog. So there's a layer cake. For me, you know, as somebody who hired and recruited and worked with a lot of talent over years, there is a you know, a meat and potatoes. There are several fundamental layers that involve thinking like a lawyer, quality of analytical thought, ability to express oneself both in asking questions and in writing and synthesizing. I mean, the best associate who ever, I would say, who worked with me in intellectual property, he has a humanities background, not an engineer. And the cool thing for me was I was unable to edit his documents. I tried very hard, but he was such a capable writer that you know, I couldn't do much with him. I don't think that comes from clinic experience. I think that's, you know, A, partly what students bring to the table, but B, that's part of what the overall law school experience is exposing them to. You're developing talented, brilliant lawyers. So I think what we're trying to overlay on top of that, what I'm trying to develop in here, is maybe help students get over some fear about, you know, how dare I even engage these kinds of questions. I'm going to throw them into the swimming pool and get them to overcome that fear. And giving them something of a framework of, you know, we want them to do that in a responsible way. So I'll say, well, you do belong in the swimming pool because these are questions that aren't being asked today, need to be asked. And actually, that reminds me of, I just wanted to add to, in answer to your question, Praveen, I think samples will give students a great deal of support. So, I mean, in doing this, you know, I put two sort of sanitized samples into these slides, but I mean, the material that I would want to develop for a clinic like this would be rich in prior examples. Because the prior example shows you ways of doing it. It never answers the question of the current client who comes in with completely different technology, but it begins to show you ways of looking at it. That's my stock in trade. There are, you know, many ways of, many examples of having done this in the past, and I think you prepare a nice set of resource materials. It allows students to interact with each other and with the client, that they build the skill of being capable in that area. I still wouldn't expect any of them to come out and handle this stuff by themselves without supervision. So, but you know, they're going to get a chance to play a little bit over their head in a clinic setting with light supervision.
This presentation is focused a lot on this stage you have up here, which is, you know, someone brings you an idea. And then later on you said you could also do IP transactions and advocacy. And you know, an IP transaction, you have, at that point the IP is established, you've already done this analysis. In your ideal clinic, what is the proportion of the work between those two? And you know, how, from an education standpoint, your own personal interest, you know, how much of it is that licensing side and the transactional side?
I would say that I would call this the core. In fact, I think I did call it the core, you know, the core exercise. The reason that other work is likely is for several reasons. One, because that's what the real world does produce. It's useful to have some exposure to it. I think some students will be interested in that. I'm interested in it somewhat. I think the best way, the healthiest way to encounter this is in the context of, well, you know, let's see what kind of comes with the package when you engage with a particular client. So there is actually, I would say, early stage transactional work that can be done even at this very early stage, which has to do with issues like rights clearance. You know, let's make sure. So Penn, you know, there are interesting ownership issues. Penn professors collaborate with other people outside of Penn. You know, maybe students, you have to look at whether is the IP actually owned by the people who you think own it. So that's a dialogue that's very important to have early on. And then there are certain assignment agreements or paper you look for that you can assess. And there's a skill set there that's kind of the beginnings of what you would do in a corporate diligence assignment in a private firm. Some of that just sort of comes in the package. I don't view that as intellectually, kind of expansive for students, and it doesn't kind of vault them ahead as well, but it's useful. And other advisory issues that come up, we would have to make a judgment call. I had a conversation with Praveen and other clinical faculty here about kind of how to put the difficulty sometimes of putting boundaries. Once a problem comes in, sometimes you wind up having to deal with a lot. I believe for various reasons we'll be able to be pretty well boundaried. I think that the general model will be selectivity to meet educational goals. If we do take clients that are external to Penn, they will be represented clients. They won't be unrepresented indigents. So, they're coming to us because there's an area, there's a sweet spot that we can hit for them that is good for us, gives students a good educational learning experience, and that they would have a hard time doing on their own on budget with law firms, but they do have law firms as, for all of their final decisions and most important issues.
So I said one follow-up on that.
Sure.
So if you were planning on representing represented clients, and I imagine that these firms could do that work just as well as a clinic could, and so let's say the client comes to the clinic because obviously free is better than paying, but at the same time, let's say that the partner at that firm calls you and says, hey, excuse me, I hear my client. How would you deal with that?
Well, so this is the dialogue that happens right now. Let's say they're represented by, I'll use the name Wilson Sonsini because they're so large, they won't take offense. They do such great work. But they're representing a lot of startup companies. The people in those startups, let's say Stanford graduates or whatever, and the people on their advisory boards know lots of people. They tell them, you got to use Wilson Sonsini as your core counsel because that's going to really connect you with the investment community, and they know what they're doing. At the same time, they and Wilson Sonsini tell those guys, you should call Stephen because he won't charge you, and you've only got $50K to file patent applications, and there's a lot of help you need with this. I'm not competing because I'm in-house. When I was not in-house, when I actually was competitive in a law firm context, even there were often opportunities to kind of play alongside and do some things that the law firms didn't do. But there we were competing for the same budget. When you're not competing for the same budget, look, the law firm and its decision makers, who are often the investors, the advisory board, and the actual board of directors, and the management of the company, they want the best IP assets they can get. They know that if they have only a certain amount of money to pay their law firm, they have a problem, because if they spend it all on strategy, then there's nothing left to do to actually file. So a lot of times they just say, well, let's just file the first 3 things that come up, and then they're kind of out of money. Or they get in trouble because they do some strategy work, but then they get a bill that nobody's happy with. So I actually believe the law firms themselves will say, hey, here's a great resource, and they'll say they'll want to have a friendly relationship so that they can actually present that in some way as we have to be careful with that and take sponsorships. But I think law firms would want to do that if they could. That's my read from being in that market.
In a way, we're in an unfair situation where we're asking you to imagine something before you're here, before you know the people. But in that spirit, one of the things that I've learned through this process, because it's not my field at all, is all the kind of cool startup stuff that seems to be happening in Philadelphia. And is there a role for our students kind of just going out and engaging? Just to sit in on them? Can they make presentations about basic IP stuff? My son was working for this little startup that had a room over donuts, and they were dying for help.
Indeed, they are. They're dying for it at all levels. If you can't do, let's say a student can't actually get up and give this presentation, but they can give a primer on why you should think about patents at all and what the first few steps would be. that actually has a lot of value. Students who can go further, on their own, absolutely. And there is also, if they're, students get admitted to a lot of places. They can walk around and run around and hear things. They're welcomed in ways that a competing company might not be. I think it would be very valuable for students in the clinic or out of the clinic to go to spend some time at places like an incubator and hear what a pitch sounds like and hear how it, I'd have to see, but I know, one of the things SRI does is incubate. And those are very valuable forums to be in, and sometimes we open them up to VCs who come in from outside. You learn a lot being involved in that. There is something called the Stanford, and MIT also has this venture lab in which startups present. It's business school run, so a lot of business students come, and business students sort of moderate it. And there's give and take. I could imagine versions of that would involve some give and take around legal issues, IP in particular, but maybe other legal entrepreneur issues that you could kind of make this be a place that entrepreneurs would come to give talks and hear feedback.
So this is in keeping with that sort of theme, which is, do you see a role for maybe not even just the students, but either the clinic more generally or the director in particular in terms of outreach, maybe around Penn or even beyond, right? Talking about technology transfer or understanding the principles of business and law and innovation. Is there a role for this clinic or the clinic director to evangelize or to talk about that to others?
100%. I would hope so. I would say that the outreach role is a significant piece, and it's one of the things that's interesting to me personally. Using law firm lingo, maybe I call it business development, but it's basically looking for relationships that will bring the right kind of project flow that will connect us in a valuable way, not to earn revenue, but to get flow and to actually have impact or become more of a reference point for people. That would be, I think, an important part of the job.
Questions?
Well, I take it you agree then. Thank you very, very much.
Even more excited.
Thank you.
All right. So let's
And I will see you later in the afternoon.
Yes. Okay, sir.
Good.
Thanks, Steve.
Oh, good.
Did you? Oh, I'll be interested in what you think. I was in the Apple store on Saturday, just looking at it. Yes. But I didn't walk out with one. Not yet.
Well, I didn't have one, so you are.
Yeah, exactly. I'll be interested in your thoughts.
All right.
Yeah. Yes.
Does not want to turn off.
Oh, I thought I logged out.
You did. The off light's just flashing and the projector's still on. I don't know why.
sure. I have to like run back there because I have a student. Yeah.
Well, that's why, we blame you. That's occupational health. So we were just talking about our intramural basketball team. Just look at us in the playing game. We won some games, the last one was a 50-point loss.
Wow. We have to stop counting.
No, the students don't do that.
And the way they have this league set up, it's margin of victory, the differential is factors into the standings. So there's incentive to run up the score.
Well, they should do what some of the computer ratings do. You can do that until say 20 points, and then after that, just let it go. Because that,
I agree. I agree.
If you say something, I should
Yes and no. No, so there's two things that they've actually adopted. So number one, so the best thing about this league is that the playoffs are at the plus.
Steve, I don't see you, so.
So everybody, so the playoffs are the plus, it's a full day event, and so to play in the plus is kind of cool. And so, so I did get them to make it that everybody will make the playoffs. There'll be an A division and a B division, but at least then everybody gets an opportunity to play along.
Maybe you may have that sweet spot where that dividing line.
Well, it's funny because my son plays in the hockey, and they were going to split the division. They were right on the cusp. The question is, do we take a game to be the best team, or we what?
Or worse than
And they closed the season against the team that they were up against, and they were just ahead in the standing. It was a very clear decision. They won. They got smoked. So, that's what.
Yeah.
It's been a lot of fun. Except for I hurt myself, but that's a different thing.
Oh,
So
really?
this is the, like, I think being on campus makes you younger, except when you play against the students.
And I think that one of the things we're commenting about is kind of in the context, someone asked me, just so you know, more than once about you, which is like, he's been a firm partner, and resources and all this. Why make this, this make sense? And I think that we forget how much fun it is to be on campus, how much fun it is to be around students. And just, we like most people in life, are notoriously ungrateful. We grouse about having the students here all the time. But, when I see the number of practice lawyers who love to come to moot court, who love just to come give a lunch talk about their careers, and it's fun to be in the building.
I teach the Texaco Pennzoil merger in my class, but from a transactional lawyering perspective, we have sort of all the parties involved and divided the class, and so each team of students represents one of those parties, whether it's the Getty Trust or Pennzoil or the museum. But anyway, so last semester, I in this reading, Bart Winokur is a Decker guy. He was the lawyer on this deal, inherited the client from a senior guy
Which side of the deal?
who died. He was the Getty oil, and so he really was the board's lawyer, but John Paul Getty was was sort of the controller of the trust, and there was sort of a schism there, and the president of the board was a different guy. Winokur was aligned with that person. Winokur was a 40-year-old young partner at the time, and so there's some really interesting decision points in this, right? And obviously it's a hostile and all this stuff. And anyway, so I sent him the reading and everything, and asked him if he wanted to come in, and he jumped at it. He was awesome. He was great, you know?
Well, there's the other things. My wife doesn't want to talk to him on my work. Certainly not something I did, some years ago. That's probably one of the landmarks of his career. I'm sure he never gets time to talk to him.
Well, because there was a, yeah, I mean, he's just a great storyteller, you know?
I was taught that case for judicial contributions in the cover damages error, you know what I'm talking about? So I'm trying to remember, the original contract that was atrociously interfered with was like 10 bill. And they eventually merged for 7 bill or 5 whatever. And so the damages are whatever, they're different. But they allowed it to go to the jury on the instruction that the damage was 10 bill, the whole lot. And it was just textbook error. But when they got to the appeal stage, the appellate bond for a $10 billion judgment is $10 billion.
Yeah.
So it's just, and they couldn't get anyone to underwrite the bond, because I mean, it's just too big, even on a syndicated basis. And so basically, there's a question lingering there, it's like, is this really access to justice? Because you have no time to, theoretically to an appeal, but, and then you start, the ugly part of this is, find that, I can't remember which side, donated $750,000 to the judicial campaign.
So it was in Texas, and it was really, so it's interesting in that it's a bunch of New York lawyers trying this case in Texas, and then obviously, Joe Jamil for Pennzoil, and which was the absolute right strategy, versus a bunch of New York lawyers, and so then it became these New York interlopers coming into Texas, but the judges, so Bart tells a story, he's on the stand, and it was near Rosh Hashanah or something like that, and he was on the stand, but he was going to have to go home for the holiday, and he tells his lawyers, and then they ask the court to continue the testimony of Bart, and the judge, Texas judge, basically puts Bart back up on the stand, and then in front of the entire courtroom explains why they have to delay this trial, because Mr. Winokur has to go back to New York City for Rosh Hashanah. Now that's a Jewish holy holiday, and this is in front of everybody, the jury and everything, right? And so he talks about sort of access to justice, but just, yeah, I mean, it's amazing.
Well, see, the punch on this is one side donated 3/4 of the bill, the other side didn't realize they were in trouble, they donated half a bill. And the 3/4 of the bill won, so And the judge, they say with a straight face, it's just one way to finance, it's you have elections, it's one way to finance elections.
It's gotten better in the patent courts in Texas. Like this favorite plaintiff form, but it used for a while, law firms from around the country, patent firms, were buying, there was if you would sponsor a bull in some local, because it's like this particular city, Marshall or something, eastern district of Texas, where the patent case is. So you could buy a prize bull, and it would have your law firm name on it, and the big rodeo. That's all these firms were buying, sponsoring bulls in the rodeo.
Interesting.
Because they want jurors to see their name. They weren't developing business. They were. It just seems overtly. That can't be right.
Yeah.
Isn't that? It's got to be a bad thing.
Depends on whose side you're on, right? Like Pennzoil, didn't think it was a bad thing.
Yeah, right.
And then you start to worry, well, we bought a bad bull.
Right.
So you just can't buy any